Stability and security of employment is an unquestionable need, important for both employer and employee. This need is also served by the establishment of labor legislation and its continuous development. One of the most important requirements for this development is that it should respond to the latest economic trends. Its protective character has to cover modern forms of employment. Related concept to the modern employment which concerns the new ways of work is the new work, which is about the goal of sustainable work. This concept can mean many things, but it certainly involves companies allowing the employees workplace flexibility. Flexibility and people-centered, individual needs-focused work organization are the cornerstones of new work. So the two strongest pillars of workplace flexibility are mobile working and the home office. This view is supported by the practice. The streaming service Spotify introduced its work from anywhere model in early 2021 in the spirit of the new work. It gives all team members freedom to choose where they want to work. Everyone can live and work in the country and the city they want. The only constant is to be in the same time zone. We can notice that even in the traditional employment relationship, work is being taken out of the employer's office. The labor market is moving towards full globalization. This flexibility is in many cases unmanageable for a traditional set of labor law concepts. The problem of the habitual place of work is a striking example. The place of work is the place where the employee actually works. It includes all the places where the employee has to fulfill the obligations arising from the employment relationship. If the parties do not define the place of work in the employment contract, the place of work is deemed to be the habitual workplace, in accordance with the provisions of the Labor Code. But whose habit are we talking about? According to the Great Commentary, if, in the absence of agreement between the parties, the usual place of work is not considered to be the place where the specific employee normally performs work, but the place where, according to the established practice of the employer, other employees normally perform their work in the given job function. This definition in the commentary is also used as a basis for judicial practice. Based on it, the workplace should not be linked to the place where the employee worked, but should be based on his or her job function description, and the practices of other employees in that job should be taken into account. It should be noted that the authors do not specify at which point in the time the practice established by other employees in the workplace is to be examined, whether it is the practice at the time of the conclusion of the contract or the practice that has continued since then and is still in existence up to the moment of the dispute. Which is problematic, just like the situation when the colleagues are working at a different office than the specific employee, because this thinking may lead to a total unrealistic result. This theory is important, as it is followed by the judiciary, even in 2021, but in my view, it is not in line with the text of the Hungarian and the EU law either. As regards the subject matter to be examined, as I believe that because both require an examination of the place of habitual performance by the employee concerned. There are even more issues with this concept also in the second theory, which raised significant controversies in relation to the habitual place of work. But we can't discuss every detail because of the time limits I try to keep. These few contradictions that have been highlighted illustrates for us how precarious the traditional framework of labor law regulation is, which is further shaken by any forms of new work in the regulation process. As mentioned before, the home office is one of the most important pillars of the new work. In order to develop the Hungarian legal institution of the home office, it is necessary to mention teleworking as a starting point, which means activities performed on a regular basis at a place other than the employer's facilities using computers, as you know, and other means of information technology, where the end product is delivered by way of electronic means. This is the traditional definition. Under teleworking, the employee's regular place of work is a place separate from the employer. It's his home or other place, such as another office. But the teleworker may work on an ad hoc basis at the employer's premises, for example, during meetings, but should be exceptional, as the regular work is at one or more places other than the office. The commentary summarizes this well. In the first line you can see that, and compares it with the home office. According to this, in the case of teleworking, the exception is that the employee has to be present at the employer's premises, for example, for meetings or trainings. But in the home office, in the case of home office, the employee works in the place provided by the employer, it means the office, and exceptionally performs the work from home. In comparison, other professors associated different rating marks with the home office. Some of them I put it in the slide. Based on Banco, the home office means that the regular work is carried on the employer's premises, and exceptionally he can work at home or elsewhere, which is different from the first definition. In my opinion, which is the last on the slide, during the home office, the work at home can be not only exceptional, but also regular, such as half of the working days in a 2 or a 4 weeks period. The position of the other authors can also be supported, so we can see that without any legal regulation, the employers have developed an unclear practice of using the home office. After these contradictions in the literature, the question of what the legislator would do on the subject was particularly important. I think the legislator slipped through the net. In order to end the debate, the legislator received 6 months ago an act on amendments, which amends the provision of the Labour Code on telework with effect from the end of the emergency situation. Although teleworking used to mean practically working from home, according to the analysis of the Central Statistical Office, yet this decision by the legislator was surprising. In practice, at home, the home office has been based on hybridity, with employees spending part of their working time at home and part at the employer's office. Under the new rules, in the case of teleworking, the employee performs work for a part or all of the time away from the employer's premises. It can be noticed that the legislator has expanded the category of teleworking to include a legitimate home office within the employment contract. From the end of the emergency situation, the teleworker can work part of his working time even regularly at the employer's premises. As regards to the place of work, the introduction of a hybrid employment relationship into telework therefore raises a number of questions. The legal consequences of teleworking are not suited to the hybrid work, but are specifically tailored to continuous remote work, and therefore, when a teleworker works at the employer's premises, it should not follow the traditional employment relationship legislation, but should think in terms of a contract structured for remote work. With this new broad aspect, teleworking cannot continue to be maintained as a separate, atypical relationship. The socially sustainable economy needs sustainable employment, which requires sustainable regulation. The category of new work concerns the work of the future, and states that flexibility, particularly in terms of where work is done, is a priority. However, it is not only the new work that calls for a review of the Hungarian rules on the workplace, as there is also uncertainty about the interpretation of, for example, the usual place of work. This is further compounded by the issue of the home office regulation and the new hybrid teleworking concept, which raises a number of questions. In view of the above, it can be said that there are many uncertainties for employees with regard to the place of work. The flexible work redefines the traditional work, and it does not fit in the box of the traditional labor law system, just like the cat does not fit in this box on the picture. Thank you for your kind attention.